that what drives him and the book is not so much the Constitution that empowers judges, but rather the brief that he has against judicial activism and the strong belief that he promotes for judicial restraint. In fact, it's so extensive as to leave the judge with almost nothing to do except defer to whatever political branches may have done that finds itself now before the court and before the judge. In other words, as with so many conservatives and conservative jurisprudence, judges and others who came out of the Warren and Burger Court era, it's far less the Constitution than the role of judges under it that drives Jay's thesis, which is, as his title says, that judges employing constitutional, cosmic constitutional theory are undermining our inalienable right to self-governance. In fact, let me just read from various parts of this to illustrate that. Early on in his argument, on page 9, he says, the great casualty of cosmic constitutional theory has been our inalienable right of self-governance. Well-intentioned though they may be, the theorists have blinded judges and scholars alike to this first principle of our constitutional order, namely self-governance. I'm going to return to that point in just a few minutes, but I want to mark it right here. And then right at the end of the book, on the very last page, Jay writes that, so what is my theory? The answer is, I have no theory. I offer only a set of worn and ordinary observations that have all been voiced many times before. There is nothing novel in the idea that judges should pay attention to the text, structure, and history of the Constitution and not go creating rights out of whole cloth, or that judges should appreciate otherness, the other branches of government, the other sovereign that is state government, the other institutions, professions, and trades that comprise the private sector. And then he concludes this by saying, or that liberty is best safeguarded when the allocation of authority to those others is respected by the courts. Well, the great problem today, the great modern problem in the 20th century, is that due to the deference of the courts to those other branches, we have a Leviathan that today has given us a debt of $16 trillion, that has given us a budget, 40% of which we borrow to carry out. And in other words, this Leviathan, I submit, is the result of the kind of judicial deference that came out of the New Deal court. And it's the major problem that we deal with today, far greater than the problem of judicial activism, in my judgment. And indeed, the regional design, as we at Cato have been arguing since the inception of the Center for Constitutional Studies, has been rent asunder by the theory that came out of progressivism as institutionalized by the New Deal court, about which I'll say something more in just a moment. Now, for all of this, however, Jay purports to have no theory, as I just read from the passage. In fact, he does have a theory, though, and we see it on page after page. It's a theory that says, as his subtitle implies, that our fundamental constitutional principle is democracy, which invariably means, of course, majoritarianism. But of course, if that's all it meant, that would be bad enough. But as public choice theorists have shown us over and over again, it means rule by special interests, those special interests who know how to work the system, realizing that concentrated benefits and dispersed costs will give them the leg up in working the political branches. And the result is, as I said a moment ago, the Leviathan that we have today. The book is divided, however, into four main parts, and it seems to me that's the great genius of this book, to focus on those four main theories. He begins with living constitutionalism, and William Brennan is, of course, his exemplar of that. He then goes to originalism by Hugo Black and Robert Bork, and there are the two main theories that, of course, are vying for attention and have been vying for attention ever since the Warren and Burger courts came onto the scene. Then he also looks at what he calls political process theory from John Hart Ely, and then pragmatism as exemplified by the works of Richard Posner, which he calls activism through anti-theory. I'm not going to say much about those third and fourth schools of thought. The two main ones are enough for the limited time that either of us has this afternoon. Starting, though, with living constitutionalism, his main criticism, and this is true of all the theories that he discusses, is that the judges are invariably driven to impose their own personal values. Well, of course, you ask the judges who are in the crosshairs of Jay what they're doing, and of course, with the exception of Brennan, who was quite clear on the point, they are not imposing their personal values. What they are doing is, they think, interpreting the Constitution. And of course, that's the great debate. Are they interpreting it correctly or incorrectly? But repeatedly through this book, we have Jay's reducing that always to personal values rather than to grappling with whether their theory of the Constitution is or is not correct. Again, I'm going to turn to that in just a moment. With respect to Brennan, however, and the living Constitution, let's be clear, Jay praises that school's fruitful definitions of commerce. And I think a passage here would be helpful, especially for this audience, to understand what he's talking about. He says, by allowing the legislative branch, this is the New Deal court, to update constitutional terms like commerce. I wasn't aware that commerce needed updating as a term, but apparently that's the case. Living constitutionalism also made contributions to democratic accountability, legislative flexibility, and judicial restraint that originalist interpretation would not allow. That's right, the Lochner Court did not allow that. It stood athwart those efforts to use the Commerce Clause as well as other parts of the alleged parts of the Constitution to expand the scope of government. He then goes to equality, and here you've got some interesting discussions of what it is that Jay has to say on this particular subject, namely that the very existence of multiple elective forums established by the Constitution presupposes that allowing different answers to some of our disputatious questions is not at all a bad way to proceed. I submit that the reason that you allowed different forums for political activity was not to allow different answers to some of the disputatious questions, but rather to check power against power. And we see that throughout the Federalist Papers. It wasn't so much to reach the best result, but to enable one locus of power to check another locus of power.